the European Center for Law and Justice. You have 10 minutes. Please proceed.
Thank you, Mr. President, Your Honors, and may it please the Chamber. I'm here today on behalf of the European Center for Law and Justice. The first question before this Chamber is whether the pretrial chamber's assessments under Article 53(1)(c) are jurisdictional for the purpose of Article 82(1)(a). The answer to that question is yes. The availability of a separate appeal procedure on preliminary issues, such as jurisdiction and admissibility, as distinct from appeals on convictions or acquittals, is, in our view, crucial to the efficient functioning of this Court, as well as the interest of justice, as highlighted in this very case. The prosecutor here was attempting to press ahead against nationals of a non-cooperative, non-state party ex parte, without any opportunity for that state's legitimate objections to jurisdiction to be considered. And the pretrial chamber reached the impugned decision on relevant matters under Article 15, including the interest of justice, without fully considering the critical information about jurisdiction and admissibility. In the case of the United States, for example, these threshold objections would include, first, the principle of customary international law, second, the existence of specific treaties between the United States and the Islamic Republic of Afghanistan, giving the United States exclusive jurisdiction over its personnel, and finally, the principle of complementarity, because the United States is demonstrably both willing and able to investigate and prosecute its own cases. As noted in paragraphs 17 and 18 of the pretrial chamber's Kenya's Article 15 decision, when the Rome Statute was being debated, there was a deep fear that, and I quote from the opinion, that providing the prosecutor with such excessive powers to trigger the jurisdiction of the court might result in abuse. The drafters sought to answer these concerns, and again quoting from the opinion, through the current text of Article 15 of the statute, which subjects the prosecutor's conclusion that a reasonable basis to proceed proprio motu with an investigation exists to review of the pretrial chamber at a very early stage of the proceedings, namely before the prosecutor may start an investigation into a situation. That is why the pretrial chamber is statutorily required, in our view, to consider these issues as part of its reasonable basis analysis. And that is why these issues should be subject to appeal under Article 82(1)(a). If it please the Court, thank you.